number 73. Counsel?
Your Honor, may I reserve 1 minute for rebuttal?
Of course.
Thank you. Good afternoon. May it please the court. Your Honors, as we speak, hundreds of people serving post-release supervision are trapped in custody indefinitely for want of a place to live more than 1,000 feet from a school. This situation is illegal and it's unnecessary. It is not authorized by statute, and as my colleagues will address shortly, it does not pass constitutional muster. The statutory argument involves the interplay between Correction Law 73 sub 10 and Penal Law 70.45 sub 3. Before I delve into it, to be very clear, the authority that DOCS seeks in this case is indefinite confinement in a residential treatment facility for up to the maximum expiration of the post-release supervision period. Because while the Second Department held and DOCS agrees that they must release someone if a SARA-compliant residence does become available, if one doesn't, that's it. You would have to serve the entire period of post-release supervision in a residential treatment facility. So, with that in mind, the statutory argument starts off with originally enacted Correction Law 7310 back in 1970, and at that point there were two different entities, the Division of Parole and the Department of Correctional Services. It provided that there could be an agreement between the two. If the Board of Parole wanted it, that the Department of Correctional Services would house someone in a residential treatment facility who was on parole or conditional release.
So when focusing on that argument and on that statute, does your argument require us to accept that there was this gap in the statutory framework for many years, which allowed the parole division to place people in residential treatment facilities, but did not allow, well, at least for the 6 months, right? But did only authorize the Department of Correctional Services to use the RTFs as a residence, but not for people that were on PRS.
That is, in fact...
We would have to find that. We would have to find that they were acting illegally for all those years, correct?
But it's true. In other words, there's no question. They don't, my adversary does not dispute that this was the case. They simply say everybody assumed that DOCS had the authority, but DOCS didn't have the authority. So there was this gap.
But where do you get that from?
I get it from...
Is there anything in the legislative history or anything that would indicate
Well,
that?
no, I'm getting it from the actual language of the statutes. In other words, 70.45 sub 3, enacted in 1998, gave the Board of Parole authority to mandate up to a 6-month period of stay in a residential treatment facility at the beginning of the PRS term. Correctional Law 7310 only provided authority for the commissioner of then DOCS to house someone in a residential treatment facility who was on parole or conditional release, not post-release supervision.
Is your argument helped at all by correction law, over here, sorry, masks make it difficult. Is your argument helped at all by correction law 2 subdivision 6 that defines residential treatment facility and includes in the people who may be, or limits the people who may be included there to people who are out on parole or conditional release? That is 7310 a sort of backwards way of adding to 2 sub 6?
Well, it's interesting you refer to Correctional Law 2 sub 6 because, in fact, it doesn't, to this day, doesn't mention post-release supervision. It's never been amended. Why? Go figure. But yes, I do think that prior to the 2011 amendment of Correctional Law 73 sub 10, but there was a total congruence between the definition under Correctional Law 2 sub 6 and Correctional Law 73 sub 10 about using RTFs for people on parole or conditional release, not post-release supervision. One thing I want to add, though, is that if you presume that the 2011 amendment to Correctional Law 7310 gave authority to confine individuals in RTF serving post-release supervision, why did the legislature, indefinitely, why did the legislature bother to enact 70.45 sub 3, since all they needed to do was precisely what they did in 2011 and just simply expand 7310 to cover people on post-release supervision? They were making it clear that post-release supervision had a limit on how long you could confine somebody in an RTF, 6 months at the very beginning of the PRS term. There's no further authority to do that, and the amendment to Correctional Law 7310 was not intended to do that. Your Honor, I do want to address, because I think it's important.
Just hold on a second, would you? On 7045 sub 3, is the core of your argument based on the court's interpretation of the phrase notwithstanding?
I don't think so.
No? Tell me why not.
I mean, Correctional Law 70, I'm sorry, Penal Law 70.45 sub 3, which I'm now going to, I apologize.
No, it's all right. Take a
Yeah,
second.
right.
Yeah, take a second.
Shall establish conditions, notwithstanding any other provision. Right. The Board of Parole may impose a condition of PRS following release that they serve it in an RTF. What other provision of law are we talking about that would change the meaning of that would provide authority that didn't exist to house someone in an RTF? It wasn't there until 2011. It simply never, the authority didn't exist for the Commissioner of Department of Correctional Services to do that.
Let me just take a side turn here for a second, all right? SARA-compliant housing. There's 4 SARA-compliant DHS shelters in New York City right now, right? Yes.
I believe that's correct.
Well,
although there
let's
may be
assume for
some-
now. That's what I've gleaned from all these cases. Apparently, there are 4. Outside the city, do you have any idea what the number is? Outside the 4 boroughs.
I do not have that information. I imagine.
Is there a geographic limit? Because the way I understand Doc's argument, well, is this one of the arguments is, I don't know if it's disingenuous or not, but it is argued that there's a lot of other places you can go besides the 4 boroughs. And why aren't those being pursued?
Well, often they are pursued, and DOCS turns them down because they say if you resided in New York City and were supervised in New York City before you came into DOCS custody, that's where you have to go back to live.
So in other words, if you're arrested, convicted in Queens, then you have to go back to one of the 4 boroughs. You can't go to Elmira, New York. And you can't go to there's no DHS shelter that you can go in Chemung or St. Lawrence County. Where certainly you're not going to be within 1,000 feet of any school quite often. It would be much easier, my point is, to meet the geographic requirements if there wasn't a restriction to where the prisoners had to go back to. Is that correct?
Yes, Your Honor, and generally speaking,
See, that's an important point that's, I think, misunderstood, because it's assumed that logically the whole state would apply, but in point of fact, it does not apply.
there's nothing preventing a person from requesting to, a residence outside of the 5 boroughs, but generally speaking, it's simply not granted. You're from New York, you're going back to New York, and you need a place to live in the New York City, in the 5 borough area.
Is that in part because of the tension with the interest to facilitate reentry into your community with which you are familiar?
It could be. I don't pretend to know the inner workings of DOCS and how they view this, but it's certainly that
Well,
could
the
be one.
legislature, obviously, in some of these statutes, has an interest in facilitating reentry, right? Promoting reentry.
Docs has, yes, they do, and I think, I agree with the notion that if an individual was able to come up with a SARA-compliant residence somewhere in New York State, the notion that they need to be held in an RTF because it's not acceptable to them to live anywhere outside of the city.
I could see in part the tension, especially when the individual has family and a support network that would, of course,
Sure.
promote reentry.
Sure.
And the kinds of programs that might be available and that docs might think are really very important to that person's successful reentry that might not be available outside of that community. But again, that is not for us to decide in that sense, right? It's sort of,
Yeah,
that's
but-
to decide based on where the person may say, well, I'm willing to live there, but if you need certain services and they're not available, that may very well be a factor. I just want to clarify something. You are not taking the position that docs cannot use on the penal law 70.45(3), subdivision 3, that docs can't use that 6-month period when someone is unable to find SARA-compliant housing. In other words, if that's the sole reason, you're not taking the position, if that's the sole reason you can't even rely on this penal law provision, correct?
That's correct. And in fact, I agree with my adversary that in fact 70.45 sub 3 does not say that if you have a SARA-compliant residence, docs must release you. That gives the board the authority to impose up to this maximum 6-month stay for any reason it deems appropriate having to do with the reentry of the individual into the community. So there's that. But I do want to, before my time is up,
Does that authority apply, counsel, excuse me for interrupting, does that same authority apply for someone who is released on post-release supervision, goes to the RTF for the first 6 months for the reentry services, released back into the community, violates post-release supervision, reincarcerated, and now he's going to be re-released again? Does the 6-month period, reentry period under 70.45(3) apply?
No, Your Honor, because the statute is clear, and if I could just look at it, it says, may impose as a condition of PRS that for a period not exceeding 6 months immediately following release from the underlying term of imprisonment. So it means at the very beginning of the PRS term, when you violate your PRS term and you are returned as a PRS violator, you are not serving your prison term, you're serving a time assessment for violating the PRS term. It's long past the 6-month period at the very beginning of the PRS term. So 70.45 sub 3, and my adversary agrees with that, does not provide authority in the case of someone like Chance McCurdy, who was returned as a PRS violator.
But why can't we find that the correction law allows docs to send Mr. McCurdy back to an RTF to be used as a residence until such time as SARA-compliant housing becomes available? What's the problem with that?
Your Honor, that's a great segue to the point I was going to be making before my time ran out, which is I want to commend Your Honors to the amicus brief put in by Prisoners Legal Services, because I think there's a lot of wisdom in that. And it talks about not just what the effect of the amendment in 2011 was on Correctional Law 7310, but what the initial intent was when it was first enacted in 1970. And as PLS points out, there's 2 classes of people covered by Correction Law 73. Subdivisions 1 through 9 deal with inmates. Subdivision 10 deals with people who are on parole, conditional, or community supervision. And it speaks of using, and we know these are different people because, for instance, Correctional Law 73 sub 5 gives docs the authority, the commissioner, at any point in time to transfer someone from an RTF back into a prison setting. That would be completely illegal for a person serving post-release supervision who has not violated their PRS term, there is no legal authority to put them back in prison, and DOCS knows that.
Well, that's a different question, and that question's not before us. How we would interpret that.
No, but my point is that one can interpret 7310 precisely as it looks, that simply if there is no other place for someone to live, but they have a right to be released, they can use, DOCS can afford them the opportunity to use the RTF as a residence. And what that means is not the conditions laid out in subdivisions 1 through 9. What that simply means is you should be free to come and go essentially as you choose, subject to the various conditions that would be put on you, meaning a curfew. You've got to be in the RTF at this point in the evening. You can't leave till this point in the morning, just like would be the case if you were in a residence in the community. You have to observe the SARA condition. You have to abide by all rules and regulations when you're in the RTF. I mean, that would be a reading that would not find there is authority to confine, to limit, to place someone in the custody of DOCS in the RTF.
Okay, so then what does that mean? Let me just follow up on this. So let's say the opening in the shelter opens up, not permanent housing, but the opening in the shelter opens up. Does this individual now get to choose? I'd rather, the shelter is dangerous, I don't want to go there. I'd rather stay here since this is a quote-unquote residence.
No, I think that at that point in time, DOCS would have absolutely the authority to say, look, this was a temporary setup because you had no SARA-compliant residence, so there's one now, so you got to go to it.
Or perhaps it has no authority to hold you here, whether you call it a residence or otherwise. Right? It doesn't
Well,
have
no
the authority
authority
to provide this space. The space is going to go to someone else for whom it is authorized to
Right,
provide
no
the space.
authority for them to hold you there, but by the same token, no right for you to say, I insist on my right to stay in the RTF, I don't want to go to a
Until I
shelter.
find permanent housing, yeah.
Thank you,
Can
Counsel.
I, Judge,
Thank you.
I'm
Yeah,
sorry,
of
I
course,
just wanted to
yeah.
ask one short question. Supreme Court had a particular remedy that didn't involve a release. What remedy are you asking for here?
Since Mr. McCurdy has long since been released,
Right.
I think one thing the court could do is convert this matter to a motion for a declaratory judgment pursuant to CPLR 103C, and then, make a determination as to the scope of the authority or lack of authority that exists in this case for DOCS to confine an individual serving PRS in an RTF who is more than 6 months past the beginning of the PRS term. Obviously, I would be asking the court to find there is no such authority.
Thank you.
Counsel?
May it please the court, Esther Merdukhaeva for DOCS. The only question presented in this case is whether DOCS has the statutory authority to temporarily place a person on post-release supervision in a statutorily compliant RTF after the first 6 months of post-release supervision have expired. The plain text of correction law...
So then what do you make of that language in of the word in 70.45.3 that Judge Fahey was pointing to, notwithstanding?
Certainly, Your Honor. The notwithstanding clause means that any other statutory authority that would displace the Board of Parole from being able to impose a mandatory 6-month residency is superseded by the language in 70.453. In other words, the notwithstanding clause is triggered only when there is another provision that creates a conflict. The notwithstanding provision by itself does not create the conflict.
Why isn't there a conflict when you've got another provision that doesn't have a maximum amount of time?
Well, Your Honor, because these two provisions serve two different purposes and there are two different sources of authority. The Second Department was correct to read both of these statutes as having independent meaning. Section 70.453 authorizes a mandatory 6-month RTF term on any person, whether or not they're subject to SARA or another type of residency restriction, and whether or not that person has or does not have housing that complies with that residency restriction. Correction Law 7310 is simply a different type of authority. It allows DOCS to use RTFs as residences during a term of community supervision, which is itself defined to expressly include post-release supervision. And what DOCS is doing here is using that authority to provide housing on a temporary basis. this. That is the only question before this court.
Counsel, can I ask you about the provided, however, language that precedes the notwithstanding? Because we have to go back a little bit. The SARA statute, as I read it, doesn't reach people on PRS, right?
The Executive Law 259C14 does not refer to PRS. Yes.
And the way you get to that is you say, but PL 7045-3 says that people on PRS, the board can treat people on PRS the same way that it treats people on conditional release or parole. And so then they can impose the same kinds of restrictions. With me so far?
Sure.
Okay. That, though, is then followed by the provided, however, notwithstanding. And I want to focus on the provided, however. Is that a restriction on the ability or the power of the board? Because that's, I think, a reasonable way to read provided, however.
Well, I think it is a restriction on the ability of the board to impose this mandatory term of RTF housing, where irrespective of whether a person has a residency restriction or is subject to that type of condition, the board is limited in imposing this mandatory term of RTF residency for those 6 months. I don't think that this provision displaces sources of authority that talk about RTFs in other contexts. And the use of Correction Law 7310 in this type of context is a different context. This is a situation where a person was out in the community, violated, was required to do a drug treatment program, and then was re-released to post-release supervision without a residence. The position that DOCS was in that circumstance is that if it released Mr. McCurdy into the community without a SARA-compliant residence, the agency would be violating its statutory mandate to enforce SARA, and Mr. McCurdy would be in violation and at risk of rearrest because he would be in the community without a SARA-compliant residence. So the Correction Law 7310 authority allows DOCS to deal with this problem that can arise at any point during a person's term of post-release supervision. The reason why there is no temporal limitation is not because DOCS is using this authority to impose a permanent condition of release. DOCS is using this as a stopgap, and that is the only...
But isn't part of the problem created by this arrangement between DOCS and DHS and the city? And as Judge Fahey pointed out, of course, someone could be allowed to live in a different part of the state where perhaps they don't have the kinds of challenges they would in trying to return to their community in the city.
Well, Your Honor, several...
So how is it not of DOC's own making is what I'm trying to say.
It is not, Your Honor. As this court said in Gonzalez, the responsibility for placing indigent sex offenders in shelter housing falls upon local departments of social service. And in this case, it is New York City operates the local Department of Social Service. Before I get into this, I will note that we have moved in the Ortiz case to strike the...
Yes, I know that.
Yes. So assuming that the court considers the extra record evidence on which all of this is based, what the extra record
Calhoun
evidence...
consent decree is public documentation, but go ahead.
What the extra record evidence makes clear is that DHS is the one that is responsible for placing offenders into the shelter system, and DOCS cannot compel DHS to accept offenders.
But so let me ask you about the decree then. Why isn't the whole problem here really a problem of the city violating its decree? I mean, isn't that what's really happened here?
Your Honor, I don't represent the city, and the decree is not at issue in this case. If the petitioners believe that the city is obligated to accept all of the SARA restricted offenders that need housing, that claim is properly brought against DHS, who is not a party to this case. And one other point that I would make in this...
Can I ask a question before you move on to the other point? Is there a reading that you could offer to us that doesn't read out the 6-month limitation that's in 7045 sub C? I've tortured through this, and it seems to me that we're in a situation where we're being required to pursue a legal reading of statutes that appear to be at cross purposes, at least partially, to solve what's really an administrative problem, which aren't enough beds in New York City to deal with people that are being released. And so that's why we're in this situation where we have 0.1% available beds, and we've got 200 or 300 people that are being incarcerated longer than the 6 months because there's really no place to put them. So Is there a reading that Docs is offering that says the 6-month limitation is still valid and we're complying with it?
Certainly, Your Honor. I think the 6-month limitation is valid when Docs imposes that condition as a mandatory 6-month term of residence, regardless of whether someone is subject to a housing restriction. So if the board has an individual and determines that individual needs more programming before they're able to reintegrate into the community, they must go to a residential treatment facility for 6 months, whether or not they have other housing that is compliant. That is subject to a 6-month limitation and has been subject to a 6-month limitation.
Are people then renewed after 6 months if they're still on PRS and kept longer? I'm not aware of that being the case.
Well, I think the people, you mean people that are subject to this condition because of...
Sure.
No, Your Honor.
Okay.
When Docs
So the 6-month
uses-
limitation isn't being complied with then? See, I'm really struggling to find some instance where you clearly comply with the 6-month limitation to meet what's, in many ways, I think, an unfair burden placed on Docs to solve a problem that may be higher than your pay grade, to put it fairly.
I appreciate that, Your Honor. I think Correction Law 7310 is used as a sort of stopgap authority in those circumstances. Docs is not saying that under Correction Law 7310, it can use the RTF as a permanent residence for a person.
Do you agree that part of the problem is whether it's as a practical matter true or whether it's a perception? But we've heard arguments, and I'm not sure any of them are before us today, but that there's no change in status. So the question about what happens when the 6 months is up, okay? And so then the authority under the penal law no longer exists to keep this person in an RTF. But now we're going to go to the corrections law and we're going to say, but we can't release you because you don't have SARA compliant housing. Therefore, we're going to temporarily keep you here until you find the housing. But as a practical matter, the argument is being made that there is no difference between how that person is treated after the end of the 6-month period and the continuation under a different statutory authority. Does that make sense?
I understand that, Your Honor, and I think some of these issues are explored in the Ortiz case, maybe a little bit more clearly than they are here, because this is just the statutory issue. I think my response to that would be that a person's post-release supervision is determined by the scheme that the legislature has imposed on post-release supervision. And in this case, the legislature has expressly envisioned that post-release supervision may be served in a residential treatment facility for at least part of the time, and has defined residential treatment facility to require certain types of programming and to require certain types of conditions. I would return to a question that Judge Wilson raised about Correction Law Section 2.6 and whether or not that definition of residential treatment facility excludes persons on post-release supervision. It does not for several reasons. I think the first is that the statute's reference to persons who are on parole or conditional release or will soon be eligible for parole is a description of the type of programming that should be available in a residential treatment facility and not a limitation on who may be housed in a residential treatment facility. I would also note that Correction Law 73.1 provides that the commissioner may transfer any inmate of a correctional facility who is eligible for community supervision, which would include people on post-release supervision, to a residential treatment facility. So there is no statutory limitation on the use of residential treatment facilities for persons on post-release supervision. To the contrary, the legislature expressly envisioned that.
So I want to go back to something you said before. I may have misunderstood you. It sounded like you were saying that pursuant to holding or having someone reside in a residential treatment facility under the authority of 70.45(3) of the penal law, that they are also going to be provided with programming. Is that correct? Is that the way you view it, that during those 6 months, there's also programming that's provided? It's not simply a residence, it's that there's programming that's going to be provided because this is to facilitate reentry.
Correct, Your Honor, and because the term residential treatment facility is defined in the governing statutes by reference.
One would think so. So let me ask you this. So at least for purposes of this case, the kinds of individuals we're talking about, do they get that programming?
Persons in RTFs do receive programming. I think that the record...
Even if they are solely there because they don't have a SARA-compliant residence to go to?
Yeah, yes, they do. They participate in work programming. They are eligible for educational opportunities. There is treatment and other types of programming that is available. Again, I think this issue is actually certainly not squarely presented in this case. I don't even think it's squarely presented in the Ortiz case, but there are cases that do deal with this issue. The Alcantara case has now reached final judgment, and the parties have cross-appealed in that case. There was another case from the Second Department recently, the Alvarez case, which resolved these issues with respect to the Queensboro RTF, where both Mr. McCurdy and Mr. Ortiz were
Alcantara
housed.
was the Albany County case?
It was,
The
yes.
miscellaneous case? It hasn't gone, they haven't argued it in the Third Department, have they?
No, the parties have filed notices of cross-appeal, but I believe neither side
No,
has
I just want to
perfected
make
it.
sure I didn't miss it. Okay.
Thank you, counsel.
Thank you.
Counsel?
Your Honor, I want to end with the fact that we're talking about the right to liberty here. And it is now, there's an average wait now of approximately 1 year confined in an RTF before someone can actually be released to the community. That period of time has been growing larger and larger and larger ever since this crisis began in 2014, when docs realized that homeless shelters were subject to the SARA restriction as well. And I do want to say that when we're talking about competing statutes and the SARA law, it would not on its face violate the SARA law for docs to release an individual to the New York City shelter system, imposing the SARA condition, but refraining from arresting that individual for violating it if no SARA compliant homeless.
So is that your response to sort of what I think Docs is really arguing here, that, you know, they know that New York City's shelter system cannot accommodate all of the individuals who are subject to SARA. And so rather than have exactly what you've described, which is someone go to a shelter system, there's no bed for them, they're out on the street, maybe they're near the school, maybe they're not. In any event, there's the very high risk of violation of SARA. Is your response to that is then just don't find them in violation of SARA?
My response is twofold. On the one hand, it's not at all clear after the decision in Bonilla that, in fact, the city DHS would not be able to accommodate everyone who needs a SARA-compliant shelter space. But even if that is not the case, my position is that the statute, that Executive Law 259C14 on its face mandates the imposition of the SARA, of the 1,000-foot school zone exclusion restriction. It does not speak to enforcement of that condition.
Counsel, doesn't that create some problems, though, for the High Court of the state to say, it just says you have to impose it, but don't worry about enforcing it. We'll just turn the other way because there are these administrative problems and encourage you not to enforce what the law says you must impose. That, to me, is more than a little problematic.
Your Honor, that was true from 2005 to 2014 when, if an individual didn't have a SARA-compliant residence they found, docs would release them to the New York City shelter system because they didn't think homeless shelters were subject to the SARA restriction. For 9 years, there's no evidence any child was ever endangered by that. But my point is this. I'm not suggesting that docs and this court simply say, yes, well, throw up our hands and look the other way. What I'm suggesting is that when you balance the right to liberty against the compliance with the SARA law, you look at the strict terms of the statute, and docs can impose the condition, make a requirement that the individual, if they are not immediately granted a SARA-compliant bed when they are presented to DHS, at the first opportunity, must move into a SARA-compliant shelter space as soon as that opportunity arises. Otherwise, they will be subject to arrest for violating the SARA condition. I think that's a balancing between the right to liberty and the enforcement of the SARA law that really should be struck in favor of the right to liberty. And I would note on the PRS question, there's an amicus from Center for Appellate Litigation, but I've included some of that in my own brief. And by saying that Penal Law 7045 sub 3 makes an individual subject to SARA who's on PRS, you're importing through the back door what the legislature did not put in through the front door. And it is not, by the language, it is docs, is not establishing the condition, the SARA condition. The legislature has established the SARA condition. If the legislature didn't put PRS in it, it's not there, and it would, for that additional reason, not technically violate the SARA law to release someone serving PRS to the city shelter system, even if no immediate SARA-compliant bed space is available. And again, we're talking about human liberty, and if the legislature messed this up and intended to include PRS in the SARA law, let them fix it, and at the same time, let them fix the mess they've created with having a law that has produced untold misery for countless human beings who are deprived of their liberty through no fault of their own.
Thank you, counsel.
Thank you.